Give it one more minute. I think everybody's in. Okay. All right. Welcome, everyone. I'm going to, again, give a brief introduction to the themes of the class, which, as you know, is introducing you to evidence-based and value-based disagreement, which, as I've said many times, is a feature of a democratic society and not a bug. That is, it's something we should expect in a free society where people have different life experiences, different families, different upbringings, different different inspirations. And it's actually a strength. And I want to mention last week I thought was an interesting example of that. In the discussions we had about fetal personhood, you saw very, very sharp disagreement between the two speakers and very different perspectives. And they actually put pressure on each other's views, but in a constructive way, so that all of us, maybe this is another message of the class, nobody gets things perfectly right. We're all vulnerable to limited perspectives and parochialism and missing things. And one of the advantages of living in a world where people have different views is you get to correct, you get to see things that you might not have seen. Even if you don't change your mind, this is a point John Stuart Mill made. He said, even when you're confronted by views that are implausible and wrong, if you just hold on to your views and never confront challenges to them, those views tend to become dead dogma, and you don't even really reflect or know why you believe what you believe. And so living in a world where you actually run into people who see things differently, it's a good epistemic, wake-up call to our own limitations and the importance of learning together and learning from each other. And I often think, when I think about an advantage of disagreement, productive disagreement, and we've talked here about productive versus non-productive disagreement. If everybody thinks, the one tool is a hammer and you have a problem, but the real tool isn't a hammer, it's it's a saw. You really want some people who think, no, there are other tools you could draw on here. And that's a big advantage of living together with people who see things differently and have different perspectives. So we will engage productively today in another discussion, this time on internet regulation, and in particular the Take It Down Act. And I will turn it over to Paul now to introduce today's speakers and the themes, and welcome again, everybody.
Before introducing the speakers, I'll just add another current event. For those of you who read the Stanford Daily, there was an article, I think, on Friday by Jessica Riskin, who is one of the co-chairs of the Stanford chapter of the AAUP, and it was against viewpoint diversity, arguing essentially that viewpoint diversity is not necessary on the campus. There's enough of it. I have an article, I think, coming out tomorrow, arguing against that. But this is a class about viewpoint diversity. The point of each of our sessions is to show that people with different viewpoints can engage each other in a constructive way. But it made me think that maybe next year, Deborah, we should add a session on viewpoint diversity to this course. But meanwhile, we have two terrific guests today talking about regulation of the media. Eric Goldman is Associate Dean for Research and Professor of Law at Santa Clara University, where he co-directs the school's High-Tech Law Institute. He teaches in areas of internet law, intellectual property, advertising and marketing law, and has written widely on these topics. Professor Goldman received his BA, JD, and MBA from UCLA. His website lists several noteworthy career milestones, beginning in 1991 when he first got his first email account. The California State Bar's IP session, IP being intellectual property section, has named Professor Goldman an IP intellectual IT vanguard, and Managing IP magazine has twice named him to a short list of IP thought leaders in North America. Professor Goldman has a forthcoming book tentatively titled How the Internet Improves Humanity. Jim Steyer is the founder and CEO of Common Sense Media, which, as you'll soon learn, is dedicated to protecting kids' safety and well-being in the digital era. Paralleling Eric's education at UCLA, Jim has both an undergraduate and a law degree from Stanford. I had the pleasure of working with Jim to found the East Palo Alto Community Law Project, I think around 1983. After working as an attorney for the NAACP Legal Defense Fund, Jim founded Children Now and later Common Sense Media, where he became the CEO. Jim has written on topics related to the missions of these organizations, and he regularly teaches as an adjunct professor at Stanford. Paralleling Eric's award, Jim has received Stanford's highest teaching award and was on Tech and Learning's list of the most influential people in EdTech. Eric and Jim will be discussing the Congressional Take It Down Act, which has become all the more salient in the last month or so with Elon Musk's Grok chatbot generating sexualized images of minors. I will sit down. Jim will begin and then talk for about 10 minutes, and then Eric. But first, let's put up the polling question.
Okay, you got the question? So I teach in this classroom. Usually, some of I've got a few students here. It's full. People usually sit in the front row. I always think it's hilarious. I've been a professor at Stanford for 35 years. You guys don't sit in the front row. You have to in my class normally. So let me do you the ground rules. I'm not going to embarrass you and make you come down. I will if you're in my big class, which you can take this fall. But the other thing is, all phones and laptops away now, please. Close them. Every phone. This is a device-free class. As long as I'm speaking, put all your devices away. Everybody, now. And by the way, I've done in a class with over 1,000 people, I've walked out and taken people's phone away. I said, please don't pull it out when Professor Goldman or Paul or Deborah's speaking, because I would like you to focus on what I'm going to say, what Eric's going to say, and the dialogue we're going to have. So thank you very much for that. So, by the way, the answer is yes to the question, but let me explain why. And first of all, it's great to be here with you, Eric. Professor Goldman's one of the really leading scholars in the United States on internet law. Deborah's a terrific scholar as well. And Paul Bress was my professor. And as he said, he helped me and a couple of my classmates found the only law office in East Palo Alto. I'm sorry you outed me on the year, Paul. That was really terrible because I was going to tell them that I was a lot younger than that. But Paul's had been an incredible figure in my life, which is why I'm so proud to speak in his class. So let me frame the context of what we're going to talk about today. And as Paul mentioned, I'm the founder and CEO of Common Sense Media. It's the biggest kids media and tech group in the world. We have 200 million users. We're in about 140,000 schools around the world. Many of you young people probably had your parents make you refer to Common Sense Media before you were allowed to use it. Movies, TV, video games, or whatever. We also write pretty much all the major legislation on tech and media in the United States and globally. And let me just frame the debate today in this way. So the tech industry has essentially gotten away with murder for about 30 years. They've been completely unregulated by the federal government, really since the 1996 Telecommunications Act, which included a get out of jail free card called Section 230 that we can get into in the discussion. But essentially, Congress and various administrations, both Democratic and Republican, have been completely missing in action for 30 years in regulating the tech platforms. Period, full stop. You can ask me questions about that afterwards, but it's a huge public problem. It's one of the reasons why social media proliferated the way that it did and caused so many issues and continues to cause so many issues. Right now, the big focus at Common Sense Media, on top of what we normally do, is the impact of AI on kids and families and education. You'll see us do a tremendous amount of work on this over the next few years. We've already started passing the major laws in the United States and Europe and Australia, where we came up with a social media ban for everybody under age 16, which I'm sure delights many of you Stanford students because you're almost there. You were a few years ago, guys. And so that's what I do. But Congress and the federal government has just basically abandoned the American people for 30 years. And in their quest to operate with impunity and no regulation, the big tech companies formed over the last 15, 20 years what I would call an unholy alliance with First Amendment absolutists. So they claim that they're out there. Elon's out there claiming he's a huge First Amendment advocate. He also claimed that he was going to run the federal government and many other things. But these guys all get up and say that they're big First Amendment advocates. Let me give you an example. We wrote the major privacy law for the United States, the California Consumer Privacy Act, in 2018. To do that, we had to split the industry and get Apple and Microsoft, Salesforce, and HP to go along with us because the big tech companies basically buy off politicians when you get down to major legislative stuff, which I'll explain later. But when we wrote that law, the major privacy law that protects you now and everybody in America, it's similar to GDPR in Europe, the ACLU and the EFF, leading civil liberties groups, opposed it, partly because they took big checks from the tech industry, and also because they had sort of an absolutist point of view on the First Amendment, which, by the way, has backfired on them and me and you and everybody's children for the last 30 years. And basically, big tech has been able to use some of those advocates as pawns, perhaps well-intended, but clearly misguided pawns. I'm referring to the people who've said that there's no way you can regulate tech or speech like we're about to talk to here, because it's not protected by the Supreme Court, by the way, folks, or the First Amendment. And so what happened is that it's really mostly because the tech industries dominate this country. They're the biggest, most powerful, successful companies in the history of the world, and certainly in the history of this country. But they have forestalled necessary regulation everywhere, particularly at the federal level since '96. And the result has been a complete disaster for kids, families, and I would argue our democracy, which is part of the title of this class. And so we shouldn't let those well-intentioned but intentionally misguided arguments that they've made under the guise of free speech go very far. And let me add sort of the context of this for this law. Again, this is the only law, this very tiny, very small law, the Take It Down Act, is the only law Congress has passed in like 25 years regulating the tech industry, which is pathetic, an embarrassment to our country and to Congress and politicians on all sides of the aisle in America. Let me explain why this law was written. First, the crimes involved with this law can lead to massive self-harm and in some cases have led to suicide. For example, from October 21 to March 23, the FBI and the Homeland Security Department, which used to be run by competent people, you can judge for yourself how they're being run now, they investigated over 13,000 reports of online financial sextortion of minors. Financial sextortion of minors in 2 years. That was when DHS and the FBI were actually run by competent, honest people. The sextortion involved at least 12,500 victims, primarily boys, and led to at least 20 suicides. Second, to know this act, it narrowly defines what must be taken down within 48 hours. Very, very narrowly defined. When you undergrads go to law school and get professors like the folks up here, you will learn that the word narrowly tailored really matters a lot. We are talking about images of people, either real or manipulated, using AI like Elon does, that are created and disseminated by bad people and bad actors to harm the person depicted or allegedly depicted. So the scope for this law for adults, that means over 18, you guys, The intimate visual depiction needs to be either intended to cause harm or to have already caused harm, including psychological, financial, or reputational harm to the identifiable individual. That must be shown in the narrowly tailored scope of this very small law. Second, the scope for minors, your sisters and brothers in high school. The scope is the intimate visual depiction needs to have either been published with intent to, 1, abuse, humiliate, harass, or degrade the minor, or 2, arouse or gratify the sexual desire of another person. So, third, under this very small law that they passed, led by Melania Trump, she was the key vote to get the brilliant Republicans in Congress to actually vote for a law, that notification, the request has to be valid, and the notification must include in writing the physical or electronic signature of the identifiable individual, that means the victim, an identification of and information reasonably sufficient for the covered platform to locate the intimate visual depiction of the identifiable individual. Third, a brief statement that the identifiable individual, meaning victim, has a good faith belief that any intimate visual depiction identified under clause above is not consensual, including any relevant information for the covered platform to determine that the relevant visual depiction was published without the consent of the identifiable individual. That's the victim who has to report this for the law to even happen, okay? That's incredibly narrowly tailored. And finally, it has to be information sufficient to enable the covered platform. Think Facebook, Instagram, YouTube, name that, to contact the identifiable individual so you can actually find the victim. That's the law there. That's the scope. It's a very, very small step in the right direction. It's the only law Congress has passed in 25 years, partly because it's so narrow in scope. And how could you disagree with the idea that someone who is harmed in a sexual or other kind of extraordinary bullying manner doesn't have the right to go to Facebook and tell them to take it down? We passed a law in 2013 in California called the eraser button that gave everybody in California the right to do exactly the same thing. It was never challenged in court, and it's been on the books for 13 years. So ultimately, it's a very wide, very small law, and a wide-ranging collection of people came, like NCMEC. They're the biggest online advocates for anti-sexual abuse stuff. The only two big tech lobbying groups who oppose every kind of legislation that we promote, they came out in favor of this act, TechNet and Internet Works. And even many companies that are rogue companies like Facebook came out and endorsed the law. I wonder why. It's because it's so narrow and it's so obvious that you need it. And these are necessary protections for vulnerable individuals, period, full stop. So in closing, I just want to say this. You have to remember the context of this law, not just what I laid out in terms of the contents of the law and why it is completely separate from normal First Amendment protections. And I'll get into that because child sexual abuse materials, speech that is integral to crime, and obscene content are not protected by the First Amendment, okay? That's very important to remember. We'll get into that, I'm sure, in the discussion that we have. But I just want to remember, again, you to remember the context. Tech, social media, and AI are ubiquitous in your lives. That's why you all pull out your phones and your laptops immediately when you come into class, because you're just like everybody else is these days. You're just looking and addicted to that device and just so used to living on top of it 24/7. They're ubiquitous, but they've been totally unregulated by the US federal government since most of you, long before you were born, which is a disgrace, despite the fact they have a huge impact on your lives, on your friends' lives, on your family's lives, and on our democracy. So it's pretty simple. This is a very simple, obviously constitutional law. The only thing Congress has done to protect victims of the internet challenges in 30 years, and it is the small first step towards what we really need to do, which is move forward, put really serious, thoughtful, common sense guardrails around the extraordinary industry that defines our lives. This is the moment to do it. Thank you very much.
Hi, good afternoon. I want to thank the organizers of this class for including me in this topic and organizing a conversation on this topic. My first point of disagreement with Jim will be on the topic addressing a very small law. In fact, I don't see this as a very small law, and I think that it's really important that we talk about the laws that Congress is making and understand their impact. And honestly, I've been surprised at how little discussion we've had about this particular law, given that I see it as actually a pretty significant one. And I want to start by acknowledging the discomfort of having this particular conversation. We're talking about the non-consensual distribution of intimate visual depictions, and I know that that's a personal issue to many people in this room, and I want to acknowledge that. And I want to acknowledge the harms that people suffer when they are the victims of non-consensual distribution of intimate visual imagery. That's not, I think, in dispute, and I think that may be part of where Jim was trying to go when I think he was suggesting this was a no-brainer kind of law. There's an obvious set of concerns here that are of significant social import that we need to be discussing, identifying, and working to address. Because of the stakes of this, I want to make sure we set the proper baseline. First, there have been many voluntary efforts by the services that Jim referred to and others to try to provide mechanisms to remove non-consensual intimate visual depictions. It's not like we start from zero and we're now getting some new protection that hasn't existed. What we're getting is now a mandate for some things that were already being done voluntarily. And in addition, the Take It Down Act and the redeemed materials that you received talked about how there's a whole other criminal provision here that is not the subject of our vote, not the subject of our discussion, but is part of the baseline that has criminalized and governed a wide range of intimate visual depictions that are now subject to criminal protection or criminal restrictions that are part of the baseline here. So what we're going to do is we're now going to talk about what more do we need? How do we isolate what additional protections, if any, are required above and beyond that baseline? And I'll be candid, when I saw this law, this reminded me of the general genre of internet regulation that I see, which is I see a problem, let's do something. And I want to make clear that let's do something is not necessarily the kind of solution that we're looking for. It is a solution, but it doesn't necessarily tailor the solution to the problems it's trying to address, and it potentially causes all kinds of unintended consequences. I would describe the let's do something approach as the opposite of evidence-based policymaking. So when we think about what our regulators are doing, they're in this back room cooking up ways to protect their constituents. We think of them as looking for ways to connect the dots between the problem and the solution. And I think you're going to find that that's actually absent here. And I think that absence is part of why I'm so glad we're having this conversation, because it makes us question, are we going to get the results we want? Have we fixed the problem, or have we just done something? I'm going to give you 3 objections to the removal provision of the Take It Down Act. We're not discussing the criminalization provisions. We're only discussing removal provisions. Let me mention 3. The first is that there will be improper removals. This is not some unintended consequence. It is an obvious, foreseeable consequence that happens with every content regulation on the internet. That just comes along for the ride, and we need to talk about what are those improper removals and who wins and loses with respect to those. Now, if you were doing evidence-based policymaking, you line them all up. You say, let's take a look at who benefits from this law above and beyond the baseline, and then you take a look and say, who's going to be impacted by all these consequences? And again, don't call them unintended, call them unwanted, or call them unfortunate, but they are a well-known foreseeable consequence of these types of approaches. So for example, there's the category of content that will be removed that removes evidence of a crime. So a crime has been committed, the victim wants to be able to identify the evidence, it is removed. And I gave you in the blog post that I wrote up the example of Anthony Weiner. You may recall him. He was a politician. He had engaged in the basically unsolicited sending of dick pics. He claimed he had reformed his ways. And then, after he tried to make a comeback politically, he kept sending unsolicited dick pics. Now, in order for us to know that he is doing that, we need to see the evidence. If it is removed, now it actually gives him less accountability. Another category of improper removals will be what I'll call the edge cases. And every content regulation always has edge cases. In a law like this, those edge cases are going to be quite broad. We're trying to cleave between intimate visual depictions and other visual depictions that go right up to the line. And where is that line? And we're not quite sure. And that's definitely true with a situation like the definitions here that Jim mentioned, where we're actually going to have a mix of things that are clearly illegal and have been illegal for a long time, like what we call child sexual abuse material, or CSAM. That's covered by this law, but it didn't need to be. We already had laws governing that. And then it covers things like AI's depictions that you might think look a little bit like a parody. Now, there were provisions in the law trying to exclude that. Whether or not people understand where those boundaries are, that's part of the problem making content classifications. An example of this might be the Napalm Girl photo. I don't know how many of you are familiar with this. It was an iconic image of the Vietnam War. The American planes bombed a Vietnamese village, and a young girl runs out with her clothes having been burned off by napalm. And a photographer caught that moment. That became an iconic moment of, what are we doing in the Vietnam War? Are we helping or are we hurting? And we couldn't see that kind of consequence without actually seeing the visual evidence. That was an iconic photo. And it comes right at this line. Is it an intimate visual depiction of a person, and would it be removed under a statute like this? It now becomes one of those things we don't really know how to classify it. Another category of improper removals will be what I'm going to call the false reports or the heckler's veto. These are the people who are speaking up and saying, I want that depiction offline, but I don't actually have the standing to complain about it, or I do have the standing, but I'm actually exceeding the scope of my authorization. I would point out, for those of you who've been paying attention, things like Project 2025, which was the playbook of the Trump administration. They've been working through that one by one by one. The playbook of the Project 2025 says we want all pornography removed online, not whether it's consensual, only for adults. They want it all gone. And this is a tool that is absolutely squarely within that playbook to provide the opportunity for anti-pornography activists to remove all adult content from the internet with this ready-made tool. Another example is that, as you've seen, we have activists throughout the country who are targeting LGBTQ content, and they keep claiming it's pornographic, or claiming that it is going to be something that would be governed by this law. And so we have the ability now to reify the culture wars to be used here to take off content that other people might say, that wasn't the point of the law. Again, not unintended, just unfortunate. The last thing I'm going to mention is that the law requires not the removal of an item that's targeted, but then the services have to go look for all other versions of that in their database. And that means that there's a risk if there's going to be the decontextualization of images. You can imagine an image like the Napalm Girl standing alone, and then you can imagine that being part of a documentary. And all of a sudden now we've targeted all the content that has these other depictions in context that might also be removed under the same law that's saying we're targeting this particular item. Now, what I'm describing is basically, straightforward errors in the system. The law makes mistakes, and it's going to make mistakes here. That happens all the time. I want to reiterate, for those of you who haven't kind of stepped back for a moment, we have a system that's designed to preclude these kinds of legally induced errors. It's called due process. The general idea is that you have someone who's going to have their legal rights affected. They get notice of the proceeding, and they get the opportunity to be heard to explain their side of the story. The Take It Down Act doesn't have any due process. There will be no due process within it. It's in fact designed to be anti-due process, to take disputes out of the court and put them in the hands of the private services and say you don't have to do any procedures to make sure that you're getting it right. So what we have is, in my mind, a degradation of due process in our society, and the Take It Down Act is just a manifestation of that. I'm going to briefly mention two other objections, and then I'm going to turn over, we'll go into some conversation here. The law is going to be enforced by the Federal Trade Commission, and I want you to just step back and think about that for a moment. Federal Trade Commission is now deciding whether or not services have made proper editorial judgments about the removal of complaints about intimate visual depictions. In other words, this is not their wheelhouse. This is not their strength. This is a weird solution to the problem. What it really does is it says to the FTC, you're good at trying to regulate consumer information in the marketplace. Why don't you also become a censorship board and check and see if publishers are properly managing requests to our satisfaction, and if not, we impose remedies. Now, if you haven't noticed, the FTC has become partisan. There's supposed to be an independent commission. No more than 3 of the 5 members are supposed to be appointed from any one party. What Trump did with all the independent commissions, he canned all the Democrats. So it has become now a Republican-only controlled body. And the chairman has said, I work for Donald Trump and J.D. Vance. This is the Trump-Vance FTC. What he has said is that he is viewing the FTC as part of the partisan machinery of our country to try to advance the partisan objectives of our government. What the Take It Down Act does is hands the FTC, now partisanized, another set of tools to go and weaponize against publishers who are doing things that they don't like. Whatever that is, that can be either with respect to intimate visual depictions, or it can be with respect to anything else. What they can do is they can say, if we don't like what you're doing, if you don't change your behavior, we're going to initiate a Take It Down investigation, and we're probably going to find something. What would you like to do? The last objection I'm going to mention is that any effort to try to remove content online is really a superficial fix to a more structural, deeper problem in our society. So there will still be people who will abuse each other using intimate visual depictions, despite the takedown procedures. There's so many ways to distribute it. Jim mentioned the sextortion problem. That always happens with private messages. The Take It Down Act does nothing. The removal provisions Take It Down Act do nothing to address that. There's emails, chats, private groups. There's always going to be ways for people to abuse each other. And in fact, I did some research on this with respect to non-consensual pornography, and my earliest legal case I could find was 1984, predates the internet, if you haven't tracked the timing. What we really need is to have proper law enforcement supervision of the internet. In fact, there's another criminal provision in the Take It Down Act that's designed to do exactly that. Now, as you may know, our federal prosecutors are now working on immigration issues. They've been pulled off of all other issues, including the enforcement of this act. So we can't really tell if this act solves the problem so long as we don't actually put the enforcement resources behind the other provisions in the law. But it really, when you ask, what is the problem and how do we solve it? I start with, how do we address the fact that humans are going to be incivil to each other, just as by virtue of being human? And I think that's where our real focus should be. Asking the questions, how can we work to make a better society? What do we need? We need more empathy training. We need people to understand how others experience victimhood, how we might be contributing to that. We need more training on that. We need more training on how to strengthen our communities, how to build closer ties to each other. And we also need our efforts to improve pro-social norms, to learn that we're all in this one together, we can work together to try and make it better. Until we make progress on that, in my mind, the Take It Down Act's removal provisions are just kind of like window dressing. Thank you very much.
So Jim, why don't you respond, and the two of you have a conversation?
First of all, I thought Eric made a really, really thoughtful presentation. And unfortunately, I think a lot of things you said are not realistic in the context of what's happened. So I want to come back to you guys and say just a few things. But I'm really interested to hear Eric's point of view, because that's about as good an explanation of how you could support this. This is the only thing Congress has done in 25 years, guys. Got to be honest with you. This is it, 28 years. It's really unbelievable, and it's an incredibly minor act. And that's because they have simply been unable to pass any efforts to regulate the platforms and the internet, et cetera. And the reason is because of and I said this on both sides of the aisle, although I agree with Eric's views of the Trump administration, obviously, and the disgrace of what they've done on immigration and with I'm a former prosecutor, what they've done with prosecutorial stuff. But look, the truth is this is a tiny area. This is intimate depictions, sexualized, intimate depictions of people where the victim themselves have to go and ask the platforms to remove it, right? This is not a broad law about CSAM, which Eric referred to. It's this tiny, it's a really, and by the way, the only reason it passed is it's so narrow, it's so tiny, because neither party at the federal level, that's why California, New York, Europe are the places that regulate tech, because the federal government has failed for many years. So number one, it's a very, very narrowly tailored law. It's going after really disgusting, intimate depictions of other people, and the victim has to go and say, please take that down. It's not a really political thing. Eric is right, by the way, that the Federal Trade Commission has become completely politicized under the Trump administration. One of the many unbelievable disgraces of this administration. But if the only reason it was under there is there's no other federal law enforcement agency that they could look for. And the truth is, if you didn't use the FTC, then you would go to state AGs. They would have to go to state AG enforcement. But that lends itself to some of the same concerns you would have with the Federal Trade Commission that Eric explained, particularly in really conservative states, right? So, and I'd say the bigger thing I would tell you is, how many of you actually trust a big tech company like Facebook or Instagram or Twitter, also known as X, or Grok, which Paul mentioned, that's the AI platform that Elon, to actually protect the interest of the public and of victims whose photos or AI-generated photos are on the internet? You really think they're going to protect you? Really? So the truth is, this is a very, very narrowly tailored law. But it's in the broader context of the fact, and so I have many other things I'd say, but at the end of the day, you should be, all of you, hoping that our government at the federal, it's really run by the states now, and you're living in the state that is essentially the federal government for tech regulation. Eric knows that. And New York is the second state for tech regulation in the United States because of the absence of federal leadership and complete abdication of responsibility. So this is this really small law. It's not affected, it doesn't cross First Amendment lines. And it's sort of a sad example of some of the abuses that occur every day on these platforms, and also the fact that our government has failed to step forward and protect you, me, and everybody else. Sorry about that.
I think we've already found our first point of agreement, if I heard you properly, which is that there wasn't a good enforcement mechanism for this law. And you said the FTC wasn't the right choice, but all other choices were also problematic. And that's right there a good warning sign. This is what happens with respect to efforts to regulate content. That's called censorship. And it's there for a reason, that the government will take advantage of any censorship powers to use it in ways that are adverse to their constituents. And so from that standpoint, that's, again, not some kind of unintended consequence. That's entirely foreseeable, and that's going to happen here as well. So I think it's a warning sign. If you're not sure who should enforce the law, it's a sign we need to think about what powers we're handing off and how they might be misused. I want to note something that might also be a point of agreement, which is this question, who do we trust? And I think if I heard you correctly, Jim, you're like, you can't trust big tech. And I'm not here to tell you that you should, although I will reiterate that they had taken a number of steps to try and address this issue on their own, so it's not like they've been completely ignorant of the problems either. But in my internet law class, I actually asked this in the first week. I put up a poll and I say, here are your options. Who are you most scared of? Are you most scared of big tech? Are you most scared of government? Are you most scared of the media or of someone else? And over half of my students, I think this year was like 75%, said they were most scared of big tech. And to me, that just blows my mind. If you look at the powers that are in the hands of the government, they're the ones that can take children away from parents. Like, big tech can't do that. They're the ones that can fire tear gas canisters at protesters or shoot them. Big tech can't do that. And so we have a trust problem in our society here that I think we're agreeing upon. But we have to recognize then that means we have to be very careful about how we allocate power into the hands of various entities, because we should note that then we need to be prepared for how it'll be misused.
You know, I just say two things. One, I agree with Eric about the trust factor. I think that's a really good point, Eric. I really do. But the truth is that, guys, first of all, the motto of Common Sense Media is sanity, not censorship. I teach First Amendment law at Stanford and did for 25 years. It's not like I would run an organization that was pro-censorship. That's our motto and has been so all around the globe for 20 years. So I really this isn't censorship. The second thing on the enforcement, which is interesting, is, look, the reason this very narrow law was written was to force the hand of the tech companies so that they would have to remove it. Eric's completely correct, by the way, that this current Federal Trade Commission it's irrelevant, and the prosecutors, when they're not resigning right now, are doing other things that probably no one on the stage agrees with. But the truth is, the enforcement of this is by the companies. They're required to go do the job they should have done in the first place. So it's a really minor law, and I would tell you that Eric's raising really important big picture questions about our society that I happen to agree with, and I would say that there are certain powers, and we've seen them, unfortunately, over the last 13 months, exercised in ways that are unique in our lifetimes, in a really horrible way. But I would say it's interesting listening to your students being afraid of big tech, because if I polled kids in my Stanford class, 1,000 kids, and said, who are you more afraid of, the big tech or Stanford, or the federal government, I think they'd probably actually also choose the large tech companies, because they know that they really, by the way, I say this working with the heads of most of them on a daily and weekly basis, people really don't trust them. They really don't. And I agree that none of us right now, or on stage, probably trust the current version of the federal government or the Justice Department, et cetera. But at the end of the day, that's not really what you're making very good points, but that's not what this issue is about. This is like a law telling tech companies you got to take down incredibly offensive images when a victim says you got to take that picture of me down. That is so logical, and it's not really an enforcement issue. It's just sort of no-brainer from that. I agree with some of the bigger picture points you're making about Eric on that.
Can I ask a little picture question?
I'm sorry, do you mind? I do want to just, I do need to circle. I disagree honestly with a lot of what Jim said, and it's kind of in these debate formats, which things do you pick and which do you let go. I do want to come back to our debate about, is this a big law or a small law? And I think that I want to make a case to you that it's a big law. Let's just acknowledge how widespread adult content is on the internet. That is a major component of how we interact with each other on the internet. And I'm guessing that there are people here who are consumers of adult content. I'm guessing there are some producers of adult content in here. And all of those individuals are going to be affected by this law. In other words, this law is targeting that entire class of content and putting it at risk. So if that's the case, this, Jim has said now a couple of times that that only the persons depicted can complain. That's what the law says. That's not what will happen. And we know that will not be the case. This is the heckler vetoes problem I was describing. There will be lots of people who will say, I am that person submitting the request, who are not that person. And there's no mechanism that will cause them not to do that. So the entire class of adult content, I expect, is going to look very, very different post this law. And that includes both content that involves people just expressing themselves, and it involves all the partisan culture war stuff that we've been discussing here. All of that now becomes in play for a very large segment of the internet.
I just have a question to bring it down to a very granular level about the process. So somebody complains, and suppose the complaint is that it was non-consensual.
It has to be
Yeah,
non-consensual.
the complaint is that it's non-consensual, but that, in fact, it was consensual. What is the process by which that is determined? What does the internet company need to do, the social media company need to do, to determine that, and when?
They have to investigate it. So they would have
I'm
to.
sorry, can you clarify where
They'd
they're
have to.
obligated
If it says it's up to the company, the platform, to validate the 4 elements of the law.
In
that it was
40
not,
in
including
48 hours.
non-consensual. And by the way, the one thing I'd say,
Let
which
me
is-
just, so
Yeah.
they need to do it in 48 hours?
I believe that's the case. Yes.
And suppose that in 48 hours, they're just not able to make that determination.
Then they wouldn't pull it down. Then they wouldn't agree with the thing. Then they wouldn't agree with the thing. And then you would go to, if someone wanted to appeal in a longer process, imagine how long that would take. The victim, okay, this is a victim who's obviously been portrayed in a very, very unfavorable light. This is not someone who's doing a solicit, putting out their own adult content or out there soliciting adult content. This is someone who has to say this is a unfair, non-consensual, intimate depiction of me that I would like take. They have to go all that way. And so if they don't, Paul, right? If it's not removed, then that's where your appeal comes, and that's where Eric was right, that because they didn't give it to state AGs, or God forbid, the current Justice Department, they would go to the Federal Trade Commission. So it's a very cumbersome process, Paul.
Just one more question.
But they make usually the company will just do it if they think it's valid.
One more
Don't
question
research it.
about process for both of you. So the internet company says we have no way in 48 hours to figuring this out. So we leave it up. Is there any legal consequence for the social media company for leaving it up during this period?
You know, Eric? I don't know.
I'm sorry, I'm stuck. This is not right. This is not describing the law. The law requires the services to go and do a full checklist of all the obligations within 48 hours. And if they are wrong, then they have violated the law, and the FTC can initiate an enforcement action against them for that violation. So if they cannot answer the question, then they cannot be confident that they've properly handled the complaint, and it comes down. And I come back to, again, this idea that it's only the people being depicted who are submitting those requests, because of the fact that there's no discouragement for people to submit false requests. And there's not going to be anyone enforcing those. There's not going to be any reason for the services to try and figure out if the requests are false or not. So this becomes basically a heckler vetoes type situation. Anyone who objects to that depiction can say, that was me, take it down, and there's no way for the services to resolve that complaint to the satisfaction of the risk of being enforced by the FTC. And so I'm just in a different world about what's mechanically going to happen. If a request comes in to remove an item, it will be taken down unless there's some clear extant evidence available in 48 hours to say, I think we can leave this up. And that's going to almost never happen.
Jim, what's your response to that?
That I was a rape prosecutor, and the number of people who the person has to prove that they're the person. Now, in a case of an AI depict, the victim who comes forward and asks to take it down has to say that's me. So I got to believe in 99.9% of the cases that's you. Mayor, look, I'm saying this because it was a very important thing for me when I was a rape prosecutor, right? So that you're essentially in the position when you're a rape prosecutor or of domestic violence, of judging the statement of the victim, right? you're in that position. I hope if some of you go on to be lawyers, that you do something like that. It's a very heavy job. Very, 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 very few people falsely cry rape, okay? I would tell you that very, 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 very few people are going to spend their time trying to somehow go say that's a depiction of me if it's false, and go after Facebook or name the platform just because they want to do that. Because unless they can show that's them, it was intimate and non-consensual, then they can't win. So I just don't see this whole false rape cry or this false. I get your point, Eric, and it's a well-taken one. But people aren't just out there spending all their time going out and falsely claiming that there's some horrible, disgusting nude picture of me on the internet and going bugging Facebook or Instagram about that. They have better things to do. So I just think I get the concept, but it's not what happens in practice.
So a couple things.
The guys have thousands of people who work for him in
This
his
is an
field,
uncomfortable
by the way.
conversation to use the term cry rape, and I just want to acknowledge that. That's not what we're talking about here, and that analogy, I think, is disquieting, at least to me. Okay. So we're talking, what you said, though, about the system will correct the errors, that's called due process. And so criminal prosecutions involving sexual abuse are covered by due process. And I just explained earlier, this system has nothing to do with due process. This system is a bypass to due process. And so all the checks and balances that we think should be in a system to make sure that we get things right, that's expressly what this law was designed not to do. Now, with respect to false claims, I'm just going to give you some stats here. With respect to copyright infringement, this was studied, and a majority of takedown notices were difficult to substantiate or false in a copyright notice and takedown system, just like the kind of notice and takedown system we're describing here. In other words, false claims are ubiquitous on the internet. And people, if they have tools to go and mess with others, this is just another tool. So from my perspective, trying to sidestep the idea, only the victims of non-consensual intimate visual depictions will be using this mechanism actually misses the whole point of the process, that this opens up the door to everybody to do all the mischief and all of the antisocial things that we hope would not happen.
So I have a question. I think, Eric, it's more for you, because I think you've argued that there could be some limits and bad consequences from the kind of legal regulation in the Takedown Act. But your alternative, because you've admitted there was a problem, we have a real problem. Your alternative, I'm sympathetic that norms really matter, but like getting everybody to be nice to each other doesn't sound like it's the right solution. And what I heard you talking about is we've got to really think about how we treat each other and what kind of society we want. I agree with that, but I don't see that as really, I see that as having all kinds of problems too in terms of addressing the problem. So I'm just wondering, like, if you agree there's a problem, what resources do you think what levers can we pull to really effectively deal with the problem?
Right. So again, I mentioned in my opening remarks the idea that the process has to account for all the mechanisms, including the fact that services are voluntarily setting up removal processes of their own, designed to their specifications, not to this particular law's specifications, but to try to solve the problem voluntarily. And we already have a separate set of criminal provisions, many of which we had before. So the criminal provisions just kind of remix a lot of existing laws that have been on the books for many years. And we also have to have a catharsis in society. How can we not tear each other up? And that's going to be a long-term process. But if we don't fix that one, we're like really going to drive ourselves off of the cliff or off of this planet Earth. So I wasn't suggesting that's the immediate short-term fix, but I wanted to acknowledge that the short-term fixes are just trying to paper over what is ultimately a very deep structural problem in our society. And if we aren't talking about that, we're kind of missing the point.
I have more confidence. We've talked a lot about skepticism about the state and fear of the state. The state also is a way we do things together that actually have accomplished a lot. And as you say, we have mechanisms to help us accomplish a lot, including due process and rule of law, and those things are really important. But rule of law is also lawmaking, and sometimes laws actually do address problems.
But the other thing I would add, you guys, because look, this is about non-consensual, intimate, deeply offensive depictions, right? Really disgusting stuff, basically, okay? So if you do not, you go through, by the way, Eric's completely correct that there are criminal laws in various jurisdictions that if you've committed a crime in doing that, that's going to be taken care of in the next couple of years if it went through the process with the normal legal process and due process. The person who's violated, remember the victim has to bring this, is living that every moment as long as that photo's up there, guys. Every moment. 48 hours is a long period of time for someone who has a disgusting, intimate depiction of them, by non-consensual depiction of them in that position. That 48-hour period is long. And by the way, these guys have thousands of people, all the big platforms, who work in their trust and safety divisions, who clean up not just this, but all sorts of other aspects. So if you really understand how the big companies work, which I do because it's my day job, is they have people who are there 24/7 because they have other laws that they have to comply with sometimes about. But the truth is, for this law is intended to protect victims and people who've suffered online abuse. 48 hours is a long time for you to live with that. That's why I brought out the suicides. That's why I brought out the mental health component here. The idea of going through a 2-year process to decide whether or not that was actually you or not, which, again, I don't agree with Eric that there's all these people who are spending all their day long making false reports to Facebook or Google or Instagram. I just don't think that's happening, guys. So what's happening is those 48 hours for this law are bad enough. You stretch that out for weeks and months, that's the impact on the victim. That's the harm that's involved. That's an extraordinary harm to put anybody through. And I just think that this is, and again, I would come back and say, this is a tiny level of what the company should be held responsible for and aren't, except for the fact that the state of California over the last 5 or 10 years has really started to put really important guardrails, not in this particular area, but on other things like privacy and all the stuff related now to AI campaigns and other stuff like that.
Let me ask each of you a question, and then we'll open it up to students and auditors to ask you questions. You say, Jim, this is about violations of privacy. It's about non-consensual. But what it's really about is claims that something is non-consensual and sexually explicit. And just thinking about what consensual means, there's a huge amount of ambiguity of whether something, and even somebody acting in very good faith may say that something is non-consensual when a third party would say it's not. So, you're making the assumption that every claim is valid, in which case, 48 hours is surely much too long to be up. But the real issue, which I think Eric's due process concern is about, is we don't know. Even when people are acting in good faith, we don't know whether they're accurate. My question for Eric is, do you really think the existing legal structure deals adequately with this, or do you think there might be some additional law that would be useful to get after the problem that the law gets after?
Go ahead and answer.
I think it's a good, I think Paul's question's a good question. Could you, look, as I said, I'm such not a fan of Congress and this administration in what they've done. They've completely failed you. They've completely failed me. They've completely failed Eric, Paul, and Deborah. They've failed our society for more than 25 years protecting us. This is a really small area. My only point to you is that they have massive trust and they have trust and safety teams, although once Trump came in, Zuckerberg got rid of most of his trust and safety people, and so did Elon. The other guys platforms left their people in place. That's political. That's political. And Eric was pointing that out earlier, I think. But in truth, they have to validate that this is a non-consensual, intimate depiction, basically. And I'd say it's a minor step in the right direction. But the truth is, I agree that, by the way, Eric, I agree that the broader issue here is some of the polarization and some of the other ways in which our society has evolved over the last 5 or 10 years. But to me, we should be talking about much bigger, more important issues regarding how we're going to put guardrails around these platforms.
Eric, you have the last word until we get questions from our class.
Paul, I love the way you framed it because it really gets to the heart of the matter, the difference between when someone claims there's a legal violation and when there's an actual legal violation. And what we know is that there are many people who claim that their rights have been violated, who, when their story is subject to scrutiny, are not proven true. And I come back again to this, saying it's a due process problem. That's the whole point of setting up a due process problem, is to let the story emerge through some back and forth in a regulated system. And that's not what's going to take place here. Maybe one of the things that Jim and I are really just disagreeing about is what percentage of the claims that are made under this law are going to be not by the victim under the auspices of the law. And I am obviously cynical about that. I expect there to be many, not few. And if so, then we need to talk about what all that looks like. I do want to pick up one last point that Jim has used a couple of times, this notion that the depictions are deeply offensive. Now, the non-consensual nature of the image of the interaction is indeed deeply offensive. But the depictions themselves are not necessarily deeply offensive. And we need to be careful about distinguishing between adult content, pornography, and whether that has a role in our society. The reality is that it's a major part of how we talk to each other. And I don't consider that to be deeply offensive. And if that's not deeply offensive, note that that is still at stake in all of the discussion here.
Thank you. We're going to do two things as anybody lines up at the microphones. There was one on each side. The first is to renew the polling question, and let's see how it came out. You'll recall that initially there were 91% yes. Let's see whether that has changed. All right, it's gone down to 69 or 70%. And secondly, it's time to take attendance.
I got to remember to do attendance in the middle of the class. This is really good. You got to put them away after this, though. I know this. I know this law.
Okay, why don't we begin and we'll alternate microphones.
I'd like to thank both the speakers for coming out today. This has definitely been among the more lively debates we've been able to witness in the class so far. My question, I suppose, is more directed towards Professor Goldman, but I'm curious, are you aware of any systems of penalty in place for these false reports, should they be happening, and if there's a ban on your account on the app or some sort of legal penalty for trying to take down content that you are not indeed the victim of?
Yeah, it's a great question. Thank you for that. And I'm going to analogize again to copyright law because we have a notice and takedown scheme in copyright law that the Take It Down Act was modeled after, but they cloned it and then made it worse. And so what happened there is a predictor of what will happen with the Take It Down Act, but the Take It Down Act will only have worse behavior. So Congress enacted a law in the copyright realm that said you can submit notices of copyright violations and then the service is required to take it down or face liability. That was coupled with a new cause of action for anyone who was harmed by the false claim of copyright infringement, there was a provision enacted that said that someone harmed by the takedown would have a claim against the sender of the false report. And there have been like about a half dozen successful prosecution cases under that law. Almost all of them have failed. Essentially, it's really hard to draft that in a way that picks up that distinguishes between someone who is claiming but they just aren't really careful from someone who's out there maliciously trying to wreck someone's life, career, whatever it is. And so the law didn't navigate that properly. And so we have no evidence of any real effect from that particular attempt to reduce false claims in the Copyright Act. The Take It Down Act has less procedural protections than the copyright provision does, and it didn't create any cause of action at all for this issue. So if there is going to be some claims that can be brought for false claims under the Take It Down Act, it's going to have to come from some other legal doctrine. I'm not exactly sure what that is, and it's going to be extremely hard for someone to win. So that's why I keep hammering on the false claims problem, because the Take It Down Act knew that there was a problem in copyright and didn't even try to correct it.
Jim, do you want to comment briefly on this?
Yes, I just want to say to the audience and the students, this is why I don't let you take attendance in the middle of the class, because then you want your phones out for a little longer.
Okay. Colin.
Quick question. So it seems like there's a lot of
You should put them away, guys. I asked you to put them away. I'm serious.
No,
Show
your
us some respect.
time is gone for that. Now it's laptop time.
It seems like there's a lot of empirical disagreement about the feasibility question. But I think, Jim, you mentioned that California has passed a similar law 13 years ago in 2013. There's also the European law. What's the data on how successful those laws have been? And have there been false reports massively in California and in Europe? So could you give us a sense, either of you, on what we've learned from laws that have existed already?
I agree. That's a good question. And the answer is, on the eraser button, I don't think I've ever heard a single example of a false report on it. We wrote the law. Darrell Steinberg was the pro tem at the time, passed it. It applied only to people under the age of 18. And I've never heard of by the way, we've not done any definitive study of it, I would tell you, but I've never heard of it. The truth is that on the eraser button thing, it was only for people under the age of 18, so they had to exercise their rights to take the content down. And sometimes maybe but as far as I'm aware, it hasn't actually been utilized in a false way, but it probably hasn't been utilized as much as you would think by people who would want to take it down. And my guess, and this is a complete guess, because I don't think there's any data, I've never seen any data about this law, right? By the way, this is not a law that Common Sense was involved in or supported or anything, by the way. We thought it was at the margins, and we thought it was sort of a pathetic attempt by Congress to say they had done something in 25 years. But I haven't seen any data about how many claims have been done, false claims, anything like that. So I don't know if there's any data. It's only been on the books for, I don't know, probably less than a year, so I don't know. But I know with the eraser button, I've never seen any studies about it, but I've never heard about false claims or accurate claims or anything about that law, honestly.
So the Take It Down Act's removal provision is not yet effective. So there's no data on it because it hasn't even come into effect. That's why I've been trying to explain to you is that the internet is about to change, I think, in significant ways, because this law is like, it's in the system. And when it hits, I think you're going to notice. Why I'm so glad we're having this conversation. Now, with respect to the California eraser button that Jim mentioned, and I'm sorry, Jim, I don't mean to trash your efforts, but that law, I think, has been...
I'm not worried that the world will worry that you trashed my efforts.
That law has basically been ignored. It's one of those many laws on the books, which there are thousands in California that are on the books. They look really important. There's a big haboo when they get passed, and then everyone ignores it. And that's what happened to that particular law. So we don't have evidence about false claims or anything, because I honestly think no one is paying attention to that law. And I'm guessing almost every single person in this room had no idea. If you grew up here in California, you were the beneficiary of this law, and you probably didn't even know it. Now, with respect to the GDPR, you were mentioning that Europe enacted a law to remove certain search results from that were what I call the vanity search results. If you're searching on your name and there was something that you thought was inappropriate in there, the European Union created a mechanism to remove some of those results. And Google is the real party in interest here, and Google has published data about this, and the data basically says that they've removed about half of the complaints that they've received under that law. Now, Google has no incentive to stand up for content. It's another law that says if you don't remove it and you should have, the government can punish you. So Google's incentive is to remove it. Half of them, they've chosen not to do that. That's a good example that maybe half of those were not legitimate.
I don't agree with that at all. We helped write GDPR. I don't believe that at all. I don't think that's even an accurate statement. And the truth is, we helped write GDPR. It is not a perfect law, like no laws are perfect law. It introduced the right to privacy and online privacy to the world. It's seen all across Europe and the world as a landmark law. To take it down in that way is really not an honest thing to do, in my opinion. And more importantly, let me finish. We've written incredibly important laws in California that I am really proud of. They have protected the rights, the privacy rights, and many other rights of everybody in this room, everybody in this country, and across the world. And to have them said they're minor little laws that don't really matter. They go to the fundamental core of your right to privacy, your right to not be harassed and intimidated, and in an area where the companies are not motivated by your best interest, but are motivated by making money. So I do object to the idea that the work that we and other people have done to set privacy laws and other really important laws that protect every one of you are sort of offhandedly dismissed. Because one law that was written in 2013 before anybody else did it, and before anybody else understood the problem, may have not been that well enforced or that often, is really unfortunate. Because if we live in that world, we are really in trouble as a society if we don't think we can regulate large tech companies for the violations that they have done. And I'm afraid that when you make comments like that, you lend a sort of a cynical effort, and you allow the companies to have the ability to get away with stuff as if these laws don't really matter. I guarantee you they do when it comes to GDPR or the privacy laws or a number of the other major laws that have been written and voted upon in Europe, California, New York, even the social media ban in Australia now, that have transformed the public's understanding of their own rights. So I think we should be, I know you didn't mean it that disrespectfully, but to someone whose organization has built the construct for this, it feels that the comments feel disrespectful to the extraordinary achievements they've been since they were over the objection of the largest, most powerful companies in the history of the world who objected to privacy laws like GDPR. So this is not I don't think that's a fair characterization. Thanks.
Thanks. At the risk of oversimplifying the discussion, we're discussing victims of crimes.
Yeah.
And Jim, your objection to traditional due process, I think, would be that it takes too long, it's cumbersome, it's expensive, and it's incredibly damaging to the case of, real victims of these crimes. And Eric, I think your objection is due process and the collateral damage to content that's created that is wrongfully censored, in various circumstances. And I guess I'm wondering why the simple solution isn't, given the sensitive nature of these discussions, I'm wondering why the answer isn't take down the material within 48 hours. If there's an objection, somebody is putting their name on the line as saying, this is me, this is non-consensual, or it breaks XYZ component, and then give the content creator the opportunity to appeal it. Yeah. And then they're putting their name on the line, and guess what? If they're doing something non-consensual or offensive, they're not going to put their name on the line and go through a process to have that material rightfully restored. You gave the example of the napalm woman. That whoever owns the image rights to that could go through a very simple process and say, this is the circumstance, this is what we understand this image to be, this is why it's important, and it would be restored and it would be understood. So I guess, Eric, I'd be curious your take on that type of solution whereby, there will be false claims. I believe that, but one, people are putting their names in writing on both sides, and, giving the opportunity still to go through an element of due process that's maybe slightly altered to accommodate the sensitivity of the matter.
Just to clarify, you referenced this idea that it will authenticate the names of whoever is submitting, whether it's the takedown notice initially or the appeal. Why would you assume that? In other words, people may tell the truth on that, they may not, and if the services don't investigate, then
Okay,
it's
so let's say
it's
the
just
person
it's
doesn't-
not necessarily
If
that
the
we
person
can.
puts the wrong name, the content creator still
Fair
has
enough.
to validate it.
I just want to be clear that, again, if you're assuming like people are going to tell the truth in the system, that's just not the internet I see. And so I want to make sure we don't rely upon that mechanism. I'm going to go back to the copyright analogy. Again, the Take It Down Act was an iteration of what happens in copyright. And copyright has the kind of private appeal that you're describing. There's a removal process where a copyright owner says, take it down. And then there's what's called a putback mechanism that allows for the person whose content was removed to complain and say, actually, I had the rights to post that. And at this point, we should take it out of the system of the private entity, and we should put it into the court system. And so, essentially by raising the hand, the person who's complaining gets the potential power to move it into a due process system, a bona fide due process system. When private companies try and create due process systems, they're not the same.
But IP is for financial gain. They are different.
If you'll indulge me, I will simply point out that system has been essentially not used. Far less than 1% of the removals that have taken place in copyright have been subject to a putback complaint, and those putback complaints, the law doesn't require the services to honor the putback request. It's an option for them, which I think would be required under the First Amendment. You can't force people to publish content they don't want to publish. And so at that point, it has become irrelevant in practice. So an appellate mechanism here would need to design around the failures of the copyright appellate system to figure out a way to do it better. And I think that, in my mind, trying to recreate all the benefits we have in the court system's implementation due process in a private entity, I feel like that's a fool's errand. In the end, we're never really going to be satisfied with that.
I think we should move to another question.
Can I just say that was a really good question, and I completely agree with your analysis of the law. And I don't think mixing copyright with this I think it's apples and oranges. But that was I thought your question was really well said.
You'll get an A in Jim's class.
Keep your device away.
Hi. I did have a question written down, but in the time I've been standing up here, I think there are two other things that I might want to say instead. First, Professor Steyer, I just wanted to note that the attendance form they have us fill out has a reflection section where we're supposed to write a couple sentences. I think probably that's why phones were still out, so I'd encourage you not to assume
By the way,
the
I appreciate your
worst of
I
audience.
apologize. Thank you. By the way, thank you for saying that. I mean that. Thank you. I didn't know that. Thank you.
Yeah. And then the other thing I wanted to say, Professor Goldman, thank you for modeling what I think is really respectful and honest discussion of some of these subjects for us today, even in the face of adversity. Thank you.
Thank you.
Over here. Your turn.
Thanks. Thank you both so much for being here to discuss this with us. I was just wondering, first for Professor Goldman, it seems like you were worried that Republicans, when we were talking about the FTC being in charge of this, possibly worried that Republicans will use this to target certain identity groups or use it in a partisan way. So I was wondering, would you be more open to a law like this if it was, someone else was in charge, maybe a group that hasn't proven to be so partisan? And then for Professor Steyer, do you worry about favoritism or selective use of this law since it is going to be under the FTC with its current writing?
So I think your question gets to the point where actually I think Jim and I did agree, which was that we're not sure who would not be subject to the kinds of conflicts of interest or partisanship or the abuse of power that underlies some of my concerns about the FTC. And if we don't solve that problem, then actually we got a real problem, because then, you can put the law in the books, but the incentives of the people who are enforcing it really dictate what happens. And so I don't have a better solution for you. And that's where it's been something, I think it's kind of where you were going, Deborah, like, what are the solutions here? We need both, efforts to suppress antisocial behavior. So, that's stuff like criminal law. And we need stuff like, voluntary efforts to take it down within the editorial prerogatives of publishers. And we need to teach people to make better choices. And so, I'm kind of coming up with a matrix of solutions, and none of them consolidate power, I hope, in the hands of people who might, once given that power, misuse it.
So I agree with Eric completely about his depiction of the current Federal Trade Commission. I also don't think that when this law, if it ever takes effect, that the FTC will get involved at all. I really don't. And I think that by the way, we were not involved. The first time I really paid attention to this law is when Paul and Deborah asked me if I'd speak in this class. And the reason I say that is because we do not, as an organization in the field that does this, we didn't think this was that significant. I think Eric's points about it are well taken in that way. But this was just not that big a deal. We thought this was a political law led by Melania Trump and people trying to say, hey, you see, we're doing something to protect victim rights. But we did not think this rose to the level of thing. So I would bet, even though I completely agree with Eric's characterizations of the current FTC, which is an outrage, by the way. The idea that you don't have a 3-2 FTC is mind-boggling. It's never happened before. But I just don't think this is going to get there. I think this is really something where once it does go in effect, the platforms will either do it or they won't do it. And they do have a lot of trust and safety people as long as they're doing what they're supposed to do. And I just think the appellate part of it is maybe makes sense conceptually, but in reality won't be a big issue. That's my overall assessment. But it's really the first time I ever really looked at this law, because we didn't get engaged. We thought it was such I get it from a philosophical point why it's important, Eric, but we didn't think it would have that much of an impact compared to some of the other laws that are written in California, Europe, New York, Australia, whatever.
Yes.
Thank you guys, first of all, for coming out here and talking to us. This is an incredible opportunity that we all have to hear from, industry professionals on this specific topic. This question is more posed towards you, Professor Goldman, but Professor Steyer, I know that you're kind of in the industry of these big tech companies, so I'd love to hear your perspective as well. From what I heard, you admitted that many of these companies had some regulation prior to the Take It Down Act being put in place, which meant that people could submit requests and content was taken down, and some of those requests I assume would have been real and some would have been false. So minor censorship is not the big main argument I'm hearing. It's major censorship, this mass censorship that is the potential negative effect of this law. So I guess my question is, because these big tech companies, rely on these massive data streams of content to make money, if they're seeing this mass censorship and these massive amount of requests for content to be taken down being made, wouldn't that incentivize them monetarily to create systems within their apps to verify content ahead of time before it's posted, while it's being posted, so they can accurately validate these requests in 48 hours? Where's the incentive? I understand in the system that we live in today that if that's how it was maintained, that maybe these companies won't have enough time to verify things in 48 hours. But when doesn't this law create a massive incentive to rebuild the data structure of an app to ensure validation even prior to content being posted?
Yeah, I appreciate the question. I want to go back though. You used the word censorship, and I want to make sure that we're clear about what that word means. It really doesn't have a single common, well-accepted definition. And so you said there's major censorship and minor censorship, and I would encourage you to think about other ways of describing that. In my mind, censorship, when I use the term, is the government mandating the suppression of content. And it's the government's intervention that does that. If a service voluntarily adopts a practice, I don't consider that to be censorship, and that's where I think the term has been co-opted. I view that as their editorial discretion. They decide what's fit for their audience, they decide certain things are not fit, they adopt procedures to try and move the things that are not fit for their audience. That's editorial discretion, just like other kinds of publishers decide what they want to show to their audiences. Now, your idea that then there's some kind of new incentive to authenticate content coming in assumes that any individual item of content is worth investing in. And the reality is that the value is at scale, not with respect to any individual item. That's why we were haggling over the procedures, what's going to happen in 48 hours. Because no single item is worth defending, worth investing in, that's why it comes off the system. And that's why there's not, unless there's widespread removal of content that has high commercial value, unless we see that, there is no incentive then to build a more industrial grade solution for any individual item of content. You deal with it when someone complains after the fact. Now, if we see like the removal of the entire category of adult content online, I think there will be some incentive to try and figure out a better solution. But I think anything less than that, I think there's just not an economic incentive to do what you're describing.
So I thought that was, by the way, I think your questions are really good. For the I just want to say, I think the students you guys asked were really good. Because I want to say again, I'm sorry if you guys had your phones out. My class is just yes or no. I showed up. So if you were using it to do that, sorry. But I've had that rule in my Stanford classes for 15 years about no phones and laptops unless you get a permission from someone.
And we have
but the
now,
broader point
we have the last question.
Let me just say that I think, because I think this is important, because the word censorship is a very important word and can be thrown around. And it's a dangerous word to use. I think Eric's answer is exactly correct. And I'm glad you said it that way, because we didn't even discuss the definition of censorship. That's why I told you that's our motto. It was really important for us. I think Eric's definition of censorship is really important for people to take away from this discussion, because that is what the censorship we're worried about. And by the way, do I believe this government does try to engage in censorship? Absolutely. For the first time in my lifetime, I worry for that form of censorship. But that's a great question.
I'll just add a comment here and not ask for a response from either of you. When a private entity, a social media company, censors or takes something down under sanction from government, then that kind of jawboning does create censorship, and I expect you would both agree with that. Last question, you're representing Donner, so it better be a great question.
What's wrong with Branner?
Thank you so much for being here today. My question is also for you, Professor Goldman, sorry, but feel free to answer it as well, Professor Steyer. I wanted to ask about your objection that the Take It Down Act doesn't have due process, which I think is a really good point. I didn't think about that. But I wanted to ask your thoughts on the possible unfortunate consequences that due process would take longer time, that would take more than 48 hours in time-sensitive cases where those claims are true. I wanted to ask your thoughts on that.
It is a known problem with due process. And let's just summarize. Due process is time-consuming and it's expensive. And that means that there's some gatekeeping that occurs in the system that is basically where we require due process, we've made a choice. We know we lose some claims that were meritorious because of that cost and time, but we value the accuracy of the output enough to make sure that we get it. And I think if you got the point about due process here and that it's not built into the system by design, then we can have that conversation and say, are there circumstances where we're willing to sacrifice due process because the harms are so great? And I think like that to me, if you take away nothing else but that from this conversation, like I think we've actually done a really good job at moving the conversation forward. I will tell you that we try to solve that due process problem in the court system with a variety of different techniques, including we have expedited relief available, what's called a temporary restraining order that can be acquired in a matter of sometimes days in order to effectuate that. But I come back again to the idea, the baseline was the services were voluntarily, in many cases, willing to remove the content without the law. And so what we're really haggling over is what new removals are going to occur that weren't being handled voluntarily. And it's that category, I think, might actually be worth fighting for due process, because the ones that were going to be the easy, low-hanging fruit, they were going to be taken care of potentially anyway.
And so I would just say, first of all, also a really good question. I agree with Eric's basic assumption of that. But I'm going to say something about Paul's question. So Paul, I run a platform with 200 million users. That's a large platform. We do that every day. We have to police our platform. So actually, that's part of my day job. And we're responsible for everything on that platform. And I thought, Eric, your answer about the editorial rights that you do, you might not like our reviews of the Harry Potter movie or of Grand Theft Auto or whatever, or even the fact that maybe we have a Brainer picture than a Donner picture on somebody's sweatshirt. But the truth is, it's a big responsibility to run a platform with 200 million users, right? It is. And Google has 2 billion or whatever. But even 200 million is a lot, guys. So I think one of the real issues here is the responsibility. This is why I kept trying to come back to you to the role of the tech world. Because in my opinion, they have an incredibly important editorial responsibility. And by the way, it can reflect the views of the people who founded the company and run the company. Hopefully they're more broad-based in the way they approach it. But it is a huge responsibility on the platforms. And to me, what I still think is this very minor law, Eric's really good points notwithstanding, you still have this issue where a handful of companies basically have this incredible power over your lives, my lives, and everybody's lives. There's almost no regulation of how they manage that. Some do it much more responsibly than others. And we all agree we don't want the government coming in and telling people how to manage that, although other societies, including in Europe, have a different set of laws and approach to that. But this has been, to me, Paul and Deborah, really interesting way to do it. Again, as I came in going, I can't even remember what the Take It Act Down actually had to say, because we didn't think it was a big deal. But this is a really interesting, broader discussion, and thank you for raising it that way, and also, Eric, thank you for sort of highlighting some of the broader implications of what's involved. And you guys asked really good questions. Really good questions.
So this was
Thank you.
really a very lively and energetic and illuminating discussion. So for Deborah and me both, we thank both of you.